Roberts v. United States Jaycees, 1984. Justice Brennan delivered the opinion of the court. This case required to address the conflict between the state's efforts to eliminate gender-based discrimination against its citizens and the constitutional freedom of association asserted by members of a private organization. In the decision under review, the Court of Appeals of 8th Circuit concluded that by requiring the United States Jaycees to admit women as full voting members, the Minnesota Human Rights Act violates the First and 14th Amendment rights. We now reverse. So the conclusion is they reverse. The issue was stated as to address a conflict between the state's efforts to eliminate gender-based discrimination against its citizens and the constitutional freedom of association asserted by members of a private organization. In the decision under review, the Court of Appeals concluded that requiring the Jaycees to admit women as full voting members, the Minnesota Human Rights Act violates. So that's the statute that requires non-discrimination. So the United States Jaycees, founded in 1920 as the Junior Chamber of Commerce, is a non-profit membership organization incorporated in Missouri with national headquarters in Tulsa, Oklahoma. The objective of the Jaycees is set out in its bylaws is to pursue such educational and charitable purposes as will promote and foster the growth and development of young men's civic organizations in the United States, designed to inculcate in the individual membership of such organization the spirit of genuine Americanism and civic interest, and as a supplementary education institution to provide them with opportunity for personal development and achievement and an avenue for intelligent participation by young men in the affairs of their community, state, and nation, and to develop true friendship and understanding among young men of all nations. Regular membership is limited to young men between the ages of 18 and 35, while associate membership is available to individuals or groups ineligible for regular membership, principally women and older men. An associate member whose dues are somewhat lower than those charged regular members may not vote, hold local or national office, or participate in certain leadership training and awards programs. The bylaws define a local chapter as any young man's organization of good repute existing in any community within the United States, organized for the purposes similar to and consistent with those of the national organization. The ultimate policy-making authority for the Jaycees rests with an annual national convention consisting of delegates from each local chapter within a national president and board of directors. At the time of the trial, August 1981, the Jaycees had approximately 295,000 members in 7,400 local chapters affiliated with 51 state organizations. There were, at the time, about 11,915 associate members. The National Organization's executive vice president estimated at trial that women associate members make up about 2% of the Jaycees' total membership. In 1974 and 25, respectively, the Minneapolis and St. Paul chapters of the Jaycees began admitting women as regular members. Currently, the memberships and boards of directors of both chapters include a substantial proportion of women. As a result, the two chapters have been in violation of the National Organization's bylaws for about 10 years. The National Organization has imposed a number of sanctions on Minneapolis and St. Paul chapters for violating the bylaws, including denying their members eligibility for state and national office or awards programs and refusing to count their membership in computing votes at national conventions. In December of 1978, the president of the National Organization advised both chapters that a motion to revoke their chapters would be considered at a forthcoming meeting of the National Board of Directors in Tulsa. Shortly after receiving this notification, members of both chapters filed charges of discrimination with the Minnesota Department of Human Rights. The complaints allege that the exclusion of women from full membership required by the National Organization's bylaws violated the Minnesota Human Rights Act, which provides in part it is unfair discriminatory practice to deny a person full and equal enjoyment of the goods, services, facilities, privileges, advantages, and accommodations of place of public accommodation because of race, color, creed, religion, disability, national origin, or sex. The term place of public accommodation is defined in the Act as a business accommodation, refreshment, entertainment, recreation, or transportation facility of any kind, whether licensed or not, whose goods, services, facilities, privileges, advantages, or accommodations are extended, offered, sold, or otherwise made available to the public. Which is not. So, extend that as far as you can. Our decisions have referred to constitutionally protected freedom of association in two senses. In one line of decisions, the court concluded that choices to enter into a mainstream certain intimate human relationships must be secured against undue intrusion by the state because of the role of such relationships in safeguarding the individual freedom that is central to our constitutional scheme. In respect, freedom of association receives protection as a fundamental element of personal liberty. In another set of decisions, the court has recognized a right to associate for the purpose of engaging in those activities provided by the First Amendment, speech, assembly, petition for the redress of grievances, and the exercise of religion. The Constitution guarantees freedom of association of this kind as an indispensable means of preserving other individual liberties. The intrinsic and instrumental features of constitutionally protected association may, of course, coincide. In particular, when the state interferes with individuals' selection of those with whom they wish to join in a common endeavor, freedom of association in both of its forms may be implicated. The Jaycees contend that this is such a case. Still, the nature of degree of constitutional protection afforded freedom of association may vary depending on the extent to which one or the other aspect of the constitutionally protected liberty is at stake in a given case. We therefore find it useful to consider separately the effect of applying the Minnesota statute to the Jaycees on what could be called members' freedom of intimate association and their freedom of expressive association. So that's what we're going to call the two kinds, term the two kinds. The court has long two kinds of First Amendment freedom of association. The court has long recognized because the Bill of Rights has designed to secure individual liberty and must afford the formation and preservation of certain kinds of highly personal relationships, a substantial measure of sanctuary from unjustified interference by the state. The personal affiliations that exemplify these considerations and that therefore suggest some relevant limitations on the relationships that might be entitled to this sort of constitutional protection are those that attend the creation and sustenance of a family, marriage, childbirth, and raising and education of children, and cohabitation with one's relatives. Among other things, therefore, they are distinguished by such attributes. I think this is a definition for intimate association. So, they are distinguished by such attributes as relative smallness, a high degree of selectivity in decisions to begin and maintain the affiliation, and seclusion from others in critical aspects of the relationship. As a general matter, only relationships with these sorts of qualities are likely to reflect the considerations that have led to an understanding of freedom of association as an intrinsic element of personal liberty. Conversely, an association lacking these qualities, such as a large business enterprise, seems remote from the concerns giving rise to this constitutional protection. Accordingly, the Constitution undoubtedly imposes constraints on the state's power to control the selection of one's spouse that would not apply to regulations affecting the choice of one's fellow employees. Between these poles, of course, lies a broad range of human relationships that may take greater or lesser claims to constitutional protection from particular incursions by the state. Determining the limits of state authority over an individual's freedom to enter into a particular association, therefore, unavoidably entails a careful assessment of where that relationship's objective characteristics locate it on a spectrum from the most intimate to the most attenuated personal attachments. We need not mark the potentially significant points on this terrain with any precision. We note that the factors that may be relevant include size, purpose, policy, selectivity, congeniality, and other characteristics that in a particular case may be pertinent. In this case, however, several features of the Jaycees clearly place the organization outside of the category of relationship worthy as this kind of constitutional protection. The undisputed facts reveal that the local members of the Jaycees are large and basically unselected groups. At the time of the state administrative hearing, the Minneapolis chapter had approximately 430 members, while the St. Paul chapter had about 400. Apart from age and sex, neither the national organizations nor the local chapters employ any criteria for judging applicants for membership. The new members are routinely recruited and admitted with no inquiry into their backgrounds. In fact, the local officer testified that he could recall no instance in which an applicant had been denied membership on any basis other than age or sex. In short, the local chapters of the Jaycees are neither small nor selective. Moreover, much of the activity central to the formation and maintenance of the association invokes the participation of strangers to that relationship. Accordingly, we conclude that the Jaycees chapter lacked the distinctive characteristics that might afford constitutional protection to the decision of the members to exclude women. An individual's freedom to speak, to worship, and to petition the government for the redress of grievances could not be vigorously protected from interference by the state unless a correlative freedom to engage in group effort toward those ends were not also guaranteed. According protection to collection effort on behalf of shared goals is especially important in preserving political and cultural diversity and in shielding dissident expression from suppression by the majority. Consequently, we have understood as implicit, and I think that's from the NAACP case, most of that language that is, about the freedom of association, and the rationale for it. Consequently, we have long understood as implicit in the right to engage in activities protected by the First Amendment a corresponding right to associate with others in pursuit of a wide variety of political, social, economic, educational, religious, and cultural ends. Government actions that may constitutionally infringe upon this freedom can take a number of forms. Among other things, government may seek to impose penalties or withhold benefits from individuals because of their membership in a disfavored group. It may attempt to require disclosure of the fact of membership in a group seeking anonymity, and it may try to interfere with the internal organization or affairs of the group. By requiring the Jaycees to admit women as full voting members, the Minnesota Act works an infringement of the last type. There can be no clearer example of an intrusion into the internal structure or affairs of an organization than a regulation that enforces the group to accept members it does not desire. Such a regulation may impair the ability of the original members to express only those views that brought them together. Freedom of association, therefore, plainly presupposes a freedom not to associate. The right to associate for expressive purposes is not, however, absolute. Infringements on that right may be justified by regulations adopted to serve compelling state interests unrelated to the suppression of ideas that cannot be achieved through the means significantly less restrictive on associated freedoms. So that's the test for the analysis. We are persuaded that Minnesota's compelling interest in eradicating discrimination against its female citizens justifies the impact that application of the statute to the Jaycees may have on male member associational freedoms. On its face, the Minnesota Act does not aim at the suppression of speech, does not distinguish between prohibited and permitted activity on the basis of viewpoint, and does not license enforcement authorities to administer the statute on the basis of such constitutionally permissible criteria. Instead, as the Minnesota Supreme Court explained, the act reflects the state's strong historical commitment to eliminating discrimination and ensuring its citizens equal access to the publicly available goods and services. That goal, which is unrelated to the suppression of expression, plainly serves compelling state interests of the highest order. In applying the Act of the Jaycees, the state has advanced those interests through the least restrictive means of achieving the ends. Indeed, the Jaycees has failed to demonstrate that the Act imposes any serious burdens on the male members' freedom of expressive association. There is, however, no basis in the record for concluding that admission of women as full voting members will impede the organization's ability to engage in these protected activities or to disseminate its preferred views. The Act requires no change in the Jaycees' creed of promoting the interests of young men, and it imposes no restriction on the association's ability to exclude individuals with ideologies or philosophies different from those of its existing members. Moreover, the Jaycees already invite women to share the group's views and philosophy and to participate in much of its training and community activities. Accordingly, any claim that admission of women as full voting members will impair a symbolic message conveyed by the very fact that women are not permitted to vote is attenuated at best. It is similarly arguable that, insofar as the Jaycees is organized to promote the views of young men, whatever those views happen to be, admission of women as voting members will change the message communicated by the group's speech because of the gender-based assumptions of the audience. Neither supposition, however, is supported by the record. In claiming that women might have a different attitude about such issues as the federal budget, school prayer, voting rights, and foreign relations, or that the organization's public positions would have a different effect in the group if the group were not a purely young men's association. The Jaycees relies solely on unsupported generalizations about the relative interests and perspectives of women and men. Although such generalizations may or may not have a statistical basis in fact, with respect to particular positions adopted by the Jaycees, we have repeatedly condemned legal decision-making that relies uncritically on such assumptions. In the absence of a showing far more substantial than that attempted by the Jaycees, we decline to indulge in the sexual stereotyping that underlies the appellee's contention that, by allowing women to vote, application of the Minnesota Act will change the content or impact of the organization's speech. In any event, even if enforcement of an act causes some incidental abridgment of the Jaycees' protected speech, that effect is no greater than is necessary to accomplish the state's legitimate purposes.